In this lesson, we're going to go over the most frequently tested and highest yielding areas of torts on the bar exam in 60 minutes or less, or in other words, we're going to go over the absolute must-know stuff in torts for the bar exam, which historically, if we look at the data, is going to be the negligence analysis as a whole, right? Duty, breach, causation, damages, and then some of the defenses to negligence. These are typically the areas where we're going to have the most opportunities on the bar exam to collect points in torts. So these are the areas I'm really going to try to break down as best as I possibly can here over the next 60 minutes or so. But with that, I'm just going to set our timer to 1 hour. Ready, set, go. And with that, we can just jump right into our negligence analysis, right? So the way that this is typically presented in torts on the bar exam is going to be through an accident that results in harm to another person, right? And I know that's a very broad description, but that's one of the things that can make torts a little bit trickier, or make negligence as an analysis a little bit trickier, because it's actually pretty hard to predict, right? There's a lot of nuances that can happen in a negligence fact pattern, and that's what we're really going to try to break down as we work through these elements, all the different little nuances and ways that it can be tested. But at its core, remember, it's going to be some sort of accident that results in harm, and the question is ultimately whether the plaintiff can hold the defendant liable for that accident to recover damages or not, right? So like classically, think about car accidents, right? Someone's texting on their phone, rear ends the person in front of them, right, results in damage. The question is, look, that defendant who rear-ended this guy may not have had any intention to harm. He may have been the most well-intentioned guy in the world, but nonetheless, right, we'll see that the plaintiff may still be able to hold this defendant liable for that accident, right, what was purely an accident under the tort cause of action we call negligence, right? So at its core, right, what we usually have is some type of accident that results in harm to another person. And the question is whether the plaintiff can hold the defendant liable for this accident, right? This is negligence. And the way that we make this determination is by applying 4 elements, right? We say that the plaintiff can hold the defendant liable for negligence if the plaintiff can establish the following 4 elements by a preponderance of the evidence. Number 1, that the defendant owed the plaintiff a duty to conform his conduct to a specific standard of care. Number 2, that the defendant breached that duty owed to the plaintiff. Number 3, that the breach was the actual and proximate cause of the plaintiff's harm. And number 4, that the plaintiff sustained actual damages, right? If the plaintiff can establish those 4 elements, duty, breach, causation, and damages, by a preponderance of the evidence, then the plaintiff is going to be able to hold the defendant liable for negligence and recover damages unless some sort of defense applies. And we'll talk about the defenses at the very end of this lesson. But we can just jump right into this. We're going to break it down element by element. Remember, the easy way to remember this in your head is just duty, breach, causation, damages. Anytime you're asking whether the plaintiff can hold the defendant liable for negligence, you want to quickly think duty, breach, causation, damages, right? So we can start with duty, right? Duty as an element is really a 2-step analysis, right? Remember, here we're asking whether the defendant owed the plaintiff a duty to conform his conduct to a specific standard of care, right? So that means our first question is a yes-no question, right? Yes, no. Did defendant owe plaintiff a duty of care, right? This is yes or no. Right? If we find the answer to this question is yes, right? The defendant did owe the plaintiff a duty of care. The next question is, okay, well, what standard of care did the defendant owe the plaintiff? So if so, right, what standard of care did defendant owe plaintiff, right? So it's really two steps when we're analyzing our first element of duty, right? Number one, yes or no, did the defendant owe the plaintiff a duty of care? Number two, if we find the answer to number one is yes, the defendant did owe the plaintiff a duty of care, second question has to be, well, what standard of care did the defendant owe the plaintiff? Right, but let's think about this first part, right? How do we determine whether the defendant owed the plaintiff a duty of care? Well, it really all comes down to whether the plaintiff is a foreseeable plaintiff, right? Foreseeable plaintiff. Right, if the plaintiff is a foreseeable plaintiff, then we say the defendant owes a duty of care to all foreseeable plaintiffs, right? And a lot of times, this can be pretty straightforward, right? An automobile driver driving down the road, right? Who would be foreseeable plaintiffs to an automobile driver, right? Pedestrians on the road, right? Pedestrians crossing crosswalks, other cars around the automobile driver, right? We would say those are all foreseeable plaintiffs to an automobile driver. What about a physician, right? Well, we know that if a physician is operating on a patient, that patient is a foreseeable plaintiff, right? If we have a landlord and a tenant, right, and the landlord is doing repairs in the tenant's unit, right, well, that tenant is a foreseeable plaintiff, right? A lot of times, just based on the relationship between the defendant and the plaintiff, it's easy to see that we have a foreseeable plaintiff. So what does it look like when the plaintiff is not foreseeable? Right, this is classically, you remember Palsgraf v. Long Island Railroad. This is a really case to refresh everybody on, because it sometimes can be beneficial to even cite this on the bar exam. It's a very seminal case. If you don't remember, I am going to fly through Palsgraf v. Long Island Railroad. Remember there we have some tracks, right? I'm just going to go through this really quickly. Remember we have these railroad tracks, and if you remember we have a train, right? That train is moving, right? We have a train on the tracks that is moving, and we have, as this train is moving on the tracks, we have a guy, right, holding this mysterious newspaper covered bag or suitcase, right? And we have some of the railroad employees pushing this guy onto the moving train, right? They're trying to help him board the train, so they're kind of pushing him onto the moving train, right? And if you remember, we have Miss Palsgraf all the way several feet away over on the other end of the tracks, kind of just minding her own business. So of course, if you remember what happens here, unbeknownst to the railroad employees, these Long Island Railroad employees, inside this briefcase is fireworks, right? Only in a torts fact pattern do we get stuff like this, but inside the briefcase, unbeknownst to the railroad employees, we have fireworks. And when they push this guy onto the moving train, the fireworks become dislodged. Of course, they explode, right? This sends a shockwave all the way down the tracks. It hits a piece of equipment over by Miss Palsgraf. That piece of equipment becomes dislodged, hits Miss Palsgraf, causing injury, right? So Miss Palsgraf sustains injury. She wants to sue Long Island Railroad for negligence. And the first question is, well, did Long Island Railroad owe Miss Palsgraf a duty of care? Well, was Miss Palsgraf a foreseeable plaintiff? And according to the majority opinion here, right, the majority opinion written by Justice Cardozo, right, he terms this as Miss Palsgraf is really outside the zone, right? She's outside this zone of foreseeable danger. So because Miss Palsgraf is outside the zone of foreseeable danger, she's really not a foreseeable plaintiff. So the railroad company did not owe Miss Palsgraf a duty of care, right? So our majority opinion is no. Right? She's not a foreseeable plaintiff. She's outside the zone of foreseeable danger. Railroad company, right? Defendant did not owe Miss Palsgraf a duty of care. Of course, we get the minority opinion written by Justice Andrews, very famous Dissent, right? He actually says here that to this first question of duty. Did Long Island Railroad owe Ms. Palsgraf a duty of care? He says yes, and then he adds a caveat, but, right? So what he ends up kind of holding in his dissent, right, or saying in his dissent, is look, when the railroad employees were pushing this dude onto the train, right, they could have foreseen harm, right? If you're pushing someone onto a moving train, harm is foreseeable to this guy. So because harm was foreseeable, right, any person who is injured as a proximate cause of your breach, right, we're going to say that you owe a duty to those people. So basically, under the Andrews approach, you owe a duty to everyone who is harmed as a proximate cause of the breach, right? You owe a duty to everyone who is harmed, which includes Ms. Palsgraf. This is more from a policy perspective of the idea you owe a larger duty of care to society, right? Even if we're not going to limit it to the zone of foreseeable danger. Right, but of course he caveats this and he says, look, but we can't forget about this crazy fact pattern, right? Unbeknownst to the railroad employees, we still have these fireworks that explode, send this shock wave down the track, dislodges equipment, hits Ms. Palsgraf. We had all this unforeseeable stuff happen, right? Where do we analyze that? That still is an important fact. He just moves it, right? He's like, the foreseeability of the plaintiff is still relevant. We just talk about it under proximate cause, right? So we would say, yeah, under the Andrews approach, the railroad company owed Ms. Palsgraf a duty of care, but the question as to whether or not she was foreseeable will be under the proximate cause analysis. And on the bar exam, right, we would probably find that here, if we went to the proximate cause analysis, even if we did say, okay, well, under the minority approach, right, maybe the defendant did owe the plaintiff a duty of care. When we get to the proximate cause analysis, we're going to say, but look, the defendant didn't, well, the defendant was not the proximate cause of the plaintiff's harm, right? This was a totally unforeseeable. We had superseding unforeseeable events that broke the chain of liability. And don't worry about that, we're going to get to proximate cause later, but the point is, right, we're going to do kind of the same analysis, we're just going to get there when we get to proximate cause. So for your purposes on the bar exam, if you see kind of a Palsgraf fact pattern, right, you apply the majority, right? Zone of foreseeable danger, did we have a foreseeable plaintiff, right? And you ask this first question, did defendant owe plaintiff a duty of care? So you'd say under the majority approach, no, right? If you had this exact fact pattern, you would say no. Plaintiff was not foreseeable, so because there was not a foreseeable plaintiff, defendant did not owe plaintiff a duty of care. Then you could say, but look, under the minority opinion and Palsgraf, a duty of care is owed to everyone who is harmed. If you could foresee harm to one person as a result, right? If you could foresee harm to one person, anyone who is harmed is a proximate cause of the breach, you would owe a duty to. So then you could say under the minority approach, yeah, look, you do owe a duty to this plaintiff, but, right, the idea of foreseeability still has to be analyzed under proximate cause, right? And then you put in parentheses like see below, right? And then you'll just analyze that you'll just do your proximate cause analysis as we're going to talk about in a second. So if you see this type of fact pattern, that's how you handle it, right? But most of the time on the bar exam, you're not going to get a Palsgraf-like fact pattern, right? A lot of times it might be as simple as an automobile driver hits a pedestrian, right? Well, you don't have to you don't go through a whole Palsgraf analysis if an automobile driver hits a pedestrian, right? Clearly, that's a foreseeable plaintiff. We would say an automobile driver clearly owes a duty of care to pedestrians, right? A doctor performing surgery. Clearly, the doctor owes a duty of care to his patients. We don't have to go through a whole Cardozo, Andrews, Palsgraf analysis. This is only reserved for cases where kind of you could say abnormal things happen, right? And we can maybe even have multiple plaintiffs. Like here, right, we would typically say in a bar exam fact pattern, we'd expect this guy to be suing too, right? If he sustained damages, we'd kind of have like plaintiff 1, and then Palsgraf would kind of be plaintiff 2. That's usually how it would be presented on the bar exam, right? And so when you have that type of thing where you have multiple plaintiffs, that's a kind of a hint that maybe we have more issues with duty, right? Where obviously this guy's within the zone of foreseeable danger. Obviously the railroad employees under any approach owe a duty to a guy they're pushing, to a patron they're pushing onto the train, right? That's more straightforward. But someone way outside on the other side of the track, right? Everything we just talked about. Okay, but that's the first question. Most of the time under a duty analysis, this first step, it's pretty straightforward, right? To be able to tell whether we have a foreseeable plaintiff or not, it's straightforward, but be aware of these Palsgraf-like fact patterns. Okay, that's everything we need to know is step number one. Okay, but if we do find, it's a more typical example, right, that the plaintiff was foreseeable, so we do find, okay, defendant owed plaintiff a standard, we do find that the plaintiff owed, we find that the defendant owed the plaintiff a duty of care. The next question is, if so, what standard of care did the defendant owe the plaintiff, right? And it's best to think about this as a spectrum of care. Right, when we get to this second step, right, we've identified, okay, defendant owes plaintiff a duty of care. That's a yes/no question. Yes, right, defendant owes plaintiff a duty of care. Next question is, what standard of care did the defendant owe the plaintiff? It's best to think of this in the terms of level of care that might have been owed as a spectrum. Right, and usually it depends on who the defendant is, right? So you always want to ask, right, who is our defendant, right? Who is defendant? Right, we'll see on our spectrum, right, and it could go even beyond, right? On the lower end of the spectrum, we're thinking about people who owe a lower standard of care. We might put children down here, right? Typically, we'll say that children engaged in non-adult activities usually owe a lower standard of care. And we might put people like physicians over here where we say, look, physicians owe a higher standard of care, right? Physicians have lots of training, intelligence, experience, all this stuff to go all these years of medical school, this and that, right? We would say that physicians typically we're going to hold to a higher standard of care, right? So we'll always ask, okay, who is the defendant? And if the defendant's a child, a professional, a physician, common carriers and innkeepers, an automobile driver, bailier, bailee, possessors of land, right? There's all these classes of defendants that have defined standards of care. And for your purposes on the bar exam, you really just have to memorize those. So I'm not going to be able to go through every specific standard of care in this video, right? But what we will do is below the video, we'll have all of that information there for you. That's just stuff that has to be memorized. It is mostly straightforward, right? Again, the main classes that you want to be aware of are going to be children, professionals, physicians, common carriers and innkeepers, automobile drivers, bailiers, bailees, and possessors of land are really going to be, if you see any of those defendants, right? The defendant is any of those classes, you know the standard of care is going to be defined, right? We call those alternative standards of care. You want to be aware of those, right? But if the defendant is none of those classes, right? And another thing you'd want to be aware of is statutes, right? That define the standard of care as a matter of law, right? So basically, if the fact pattern gives you a statute, right? If you're looking at a negligence fact pattern and you see like a torts negligence fact pattern and the facts give you a statute, you basically know you have a negligence per se issue. Usually what's happening there is the statute is defining what the level is, what the standard of care owed is as a matter of law. In that case, you'll do what we call a negligence per se analysis, which we're going to talk about in a second. But otherwise, right, if the defendant is not one of these special classes of people, right, a child or a physician, automobile driver, a possessor of land, common carriers, innkeepers, right, the defendant is not in a special class that has a special definition as to what the standard of care is, or we don't have a statute in our fact pattern that's defining what the standard of care is as a matter of law. The default standard is what we call the reasonable person, right? The reasonable person standard of care. if we don't have a special class of defendant, right, or a statute that defines what the standard of care is as a matter of law, right, our default is the reasonable person standard of care. And here we just ask, what would a reasonable person of ordinary sensibilities and average intelligence have done under like circumstances as measured by an objective test? Right? The key to this is understanding that the reasonable person analysis is objective, right? So we don't care what the subjective intentions of this defendant were if we're applying the reasonable person standard of care, right? Reasonable person standard of care doesn't matter how well-intentioned this particular defendant might have been. We don't care about the defendant's subjective intentions when we're applying a reasonable person standard of care. The question will just be, what would a reasonably prudent person of ordinary sensibilities have done under like circumstances? So this means we also ignore any types of mental or emotional disabilities. We ignore, right? If the defendant has or is trying to claim that they have some sort of mental or emotional disability and that's why they couldn't conform or they breached the standard of care, none of that's going to work if we're applying the reasonable person standard of care, right? If we're applying the reasonable person standard of care, the question is, what would a reasonably prudent person have done under the circumstances? Not what would a reasonably prudent person with this mental or emotional condition done under the circumstances? We hold this person, whoever it is, to a person of average intelligence and ordinary sensibilities, right? The defendant's going to be held to that standard. That is the reasonable person standard of care, right? The only time we would give any kind of leeway on this is if there's physical disabilities, right? So if there's physical disabilities, right, those can be considered in the analysis, though it is still an objective test. So if you had a blind defendant, the question would be, right, that's a physical disability. The question would be, what would a reasonably prudent blind person of ordinary sensibilities done under like circumstances, right? So there we would say, hey, look, a blind person wouldn't get behind a reasonably prudent blind person wouldn't try to drive an automobile, right? So you're still applying an objective test, right? But you can add physical characteristics, physical disabilities to that objective test. What would a reasonably prudent blind person done under the circumstances? What would a reasonably prudent person who is paralyzed from the waist down done under the circumstances, right? Physical disabilities you can add. Mental, emotional disabilities you would exclude altogether. But that's pretty much the objective, reasonable person standard of care. You identify, okay, you just ask, what would a reasonable person have done of ordinary sensibilities, right, under like circumstances? You identify what that is, right? What would a reasonable person have done under these circumstances? And then we get to your second element, which we're going to talk about in a minute. When you get to breach, you'll have that line identified. Here's what a reasonable person would have done, right? Then you're going to ask, okay, do the facts indicate wherever your reasonable person line is that you're this is what I think a reasonable person of ordinary sensibilities would have done in this situation, right? Did the defendant in your fact pattern conform to that standard? Did they fall below it or did they fall above it, right? If they're below that standard, right, then you're going to have a breach. If they conformed to that standard or they're above it, there's no breach, right? So that's when you get to your second element of breach. But there's still one other thing we have to talk about here, and that is negligence per se. What happens if the fact pattern gives you a statute that tells you what the standard of care is, right? It gives you the standard of care as a matter of law. Right, well, anytime you see a statute on a negligence fact pattern, it's a dead giveaway. You're pretty much always applying negligence per se. And negligence per se, if you find that there is negligence per se, it basically requires the jury to find duty and breach, right? So two elements we really have to think about here. A violation of a statute constitutes negligence per se if the plaintiff is, number one, in the class of people meant to be protected by the statute, and number two, suffers the type of harm the statute was designed to protect against, right? If both of those elements are satisfied, that's negligence per se. The jury is required to say, okay, we have duty and breach, right? If a violation of a statute, right, an unexcused violation of a statute constitutes negligence per se, jury's required to find duty and breach. So that means if the violation of the statute is the proximate cause of the plaintiff's injury, right, the actual and proximate cause of the injury, and the plaintiff has sustained actual damages, then all four elements are met, right? But what negligence per se requires of the jury is to find that there is duty and breach automatically, right? And then the question just becomes, okay, well, was the violation of the statute the actual and proximate cause of the plaintiff's injury, and did the plaintiff sustain actual damages? If so, then the other two elements are met. So negligence per se gives you duty and breach, then you still do your causation and damages analysis. If you have all four, okay, defendant is liable for negligence per se. Right, so again, two elements, right? A violation of a statute is going to constitute negligence per se if the plaintiff, number one, is in the class of people meant to be protected by the statute, and number two, suffers the type of harm the statute was designed to protect against. So this would commonly be tested with like building code violations. Say that you have a building code, some sort of statute. And remember, the fact pattern has to give you the statute. You're not responsible for knowing these types of statutes coming into the exam. On the actual fact pattern, as you're reading it, the bar examiners are going to say, oh, and by the way, in this jurisdiction, there's this statute, right? Maybe it's like the fire exit safety statute act, right? Whatever, right? And say though that you're reading and there's a statute given to you in the fact pattern that says, landlords, right, must at all times maintain working fire escapes, right? At all times, landlords must maintain working fire escapes. Well, let's say in the fact pattern, right, there's a broken fire escape and the tenant lets the landlord know, hey, you've got this broken fire escape, and the landlord ignores that, okay? Then let's say, of course, there's a fire and the plaintiff cannot escape because the fire escape isn't working, right? So there's no fire escape access. So the plaintiff is stuck and they suffer, right, smoke inhalation, which requires hospitalization and maybe some third-degree burns from the fire, right? Really serious injuries. Well, the question is, do we have negligence per se, right? Is this plaintiff, number one, in the class of people meant to be protected by the statute, right? So remember, the statute says that landlords must maintain working fire escapes at all times, right? So when the drafters, the legislators made this statute, what class of people were they trying to protect? Right? They're trying to protect tenants, right? They're trying to protect tenants from fires, right? With that type of statute. So that first element would definitely be satisfied. You know, whether the plaintiff is in the class of people meant to be protected by the statute. Yes, the tenant in this fact pattern is exactly who was meant to be protected, right? When the drafters made that law, they were trying to protect tenants by giving them, ensuring that they would have working fire escapes. Right? Your second element is going to be, is this the type of harm, right? Did the plaintiff sustain the type of harm that the statute was designed to protect against? Remember here, the plaintiff has smoke inhalation and third-degree burns, right? This is exactly what the statute was designed to protect against, right? Statute is there to make sure in the event of a fire, there's a safe way to escape so people don't get damaged by the fire with things like smoke inhalation and third-degree burns. So in that case, you would have a clear violation of the statute, right? And that violation of the statute is going to constitute negligence, because remember, the statute was the landlord is required to maintain working fire escapes at all times. The landlord was told, hey, this fire escape is broken, and didn't fix it. So we have a violation of the statute, and the plaintiff, the tenant, is in the class of people meant to be protected by the statute, and the tenant sustained the type of harm, right, smoke inhalation and third-degree burns that the statute was designed to protect against. So right there we have negligence per se. That means duty and breach as elements are satisfied, right? All that would be left is making sure that the causation element and damages element are satisfied, right? The violation of the statute must be the actual and proximate cause of the plaintiff's harm. We'll talk about how you go through a causation analysis in a minute, but the answer is going to be yes, that could be shown. And clearly here the plaintiff would have damages, right? They're going to have medical bills, everything that's related to that hospital trip, right? And the smoke inhalation and the third-degree burns, right? Probably some pain and suffering damages, right? Plaintiff, though, is going to easily be able to show actual damages. In that case, plaintiff is going to be able to establish all four elements, negligence per se. Right, so that's when you are actually given a statute in the fact pattern that identifies what the standard of care is as a matter of law. You will apply negligence per se. Thank you so much for watching this video preview of our Bar Blitz video series. If you would like to see the conclusion of this video and gain full access to our entire Bar Blitz video library, which includes coverage of the most frequently tested and highest yielding areas of law in each bar exam subject, we invite you to head over to our website and join the thousands of law students who have already enrolled in Studicata Bar Review. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com.